Good afternoon, everyone. My name is Robert Bradley, and I'm a 2L at Tulane Law School. Today, I'm here to present to you the Ninth Circuit's decision in Grimm v. Vortex Marine Construction. In particular, I will discuss this decision and its impacts on the Longshore Harbor Workers Compensation Act, or LHWCA for short. This is a case about maritime workman's comp. There's a lot of abbreviations, so I'm gonna try not to bore you guys to death on this. Before I do get into this case, however, I'd like to add some context. Terry Grimm, the plaintiff in this case, worked as a pile driver for various maritime employers, including the defendant, Vortex Marine Construction. Upon his retirement in 2010, Grimm filed a claim under the LHWCA for compensation on his 32 years of work-related injuries. Though Vortex, his most recent employer, disputed Grimm's claim, a Department of Labor administrative law judge nonetheless found in Grimm's favor and ordered Vortex to, quote, pay or reimburse Grimm for all medical expenses arising from his work-related injuries. Now that was the exact quote in his compensation award. And note that apart from that language, the compensation order did not contain any other details pertaining to calculating Grimm's awarded compensation. The Department of Labor Benefits Review Board affirmed the ALJ's compensation order, and Vortex initially appealed the BRB's decision to the Ninth Circuit, but in a last-minute move of strategy, withdrew that petition before any ruling was rendered by the Ninth Circuit. Instead, Vortex simply refused to comply with the parameters of the compensation order, forcing Grimm to rely on Medicare for his treatment. Grimm subsequently filed suit against Vortex, federal district court, for enforcement of the compensation order, as well as double damages under the Medicare Secondary Payer Act. Though Grimm's injuries were legitimate, and while Vortex's liability was all but undisputable, the district court nonetheless refused to enforce the compensation order, dismissing his suit for lack of subject matter jurisdiction. More accurately, the court ruled it was statutorily barred from enforcing Grimm's claim since it related to an LHWCA compensation order that was not sufficiently final. On appeal, the Ninth Circuit affirmed the district court's dismissal for lack of subject matter jurisdiction. For as the Ninth Circuit noted, district courts under the LHWCA are courts of a limited jurisdiction that may only enforce final compensation orders. Though Grimm's compensation ordered Vortex to, quote, pay or reimburse Grimm for all medical expenses arising from his work-related injuries, though this compensation award defined the recovery Grimm was entitled to, the court nonetheless found that it was insufficiently final. The court reached its decision by adopting the Fifth Circuit's analysis for finality in Severin v. Exxon Corp., noting that in order for an ALJ compensation order to be sufficiently final, it must, quote, at a minimum, specify the amount of compensation due or provide a means of calculating the correct amount without resorting to extra recorded facts, which are potentially subject to genuine dispute between the parties. Here, the court found that Grimm's compensation order was overbroad since its monetary sweep was subject to genuine dispute between the parties. And this could impermissibly place the district court in a position of adjudicating rather than enforcing Grimm's compensation order. After effectively invalidating the claim awarded to Grimm under the LHWCA, the Ninth Circuit further ruled that Grimm's claim for relief under the Medicare Secondary Payer Act was now premature, since Grimm was now without any primary care plan. Since that ruling, Grimm has submitted a petition for rehearing to the Ninth Circuit. That petition has been denied. Further, his current attorney has requested compensation receipts from his current employer. Those requests have been ignored. But even more damning, Terry Grimm to this day remains without any awarded compensation under the LHWCA. In this case, joining the opinion of the Second and Fifth Circuits, the Ninth Circuit's reasoning in this case, while logically sound, fails to fully consider the sensitivity and urgency of individuals' LHWCA claims. For the Severin analysis will effectively preclude district courts from adjudicating any matter that could, even in the abstract, constitute the merits of a longshoreman's claim. Both seamen and longshoremen have both enjoyed a particular solicitude in the federal justice system. In fact, as early as 1823, Justice Story adopted these individuals as wards of the court. While this statement initially applied to seamen, the Supreme Court has since extended this sentiment to longshoremen as well in Garrett v. Moore McCormick. Unfortunately, the jurisprudential trend of adopting Severin analysis, as outlined in this case, threatens these wards of the court by placing an unnecessarily stringent roadblock on the legitimate claims of these injured maritime employees. Further, courts have yet to reconcile finality with formality under the LHWCA compensation order scheme. As it currently stands, many circuit courts continue to find that ALJ compensation orders in and of themselves stand as an adjudicated disposition of the individual's status as a longshoreman. The inverse is true with adequately adjudicated awards under the Jones Act. Therefore, in these circuits, an individual who receives a formal award under the LHWCA is collaterally stopped from pursuing a simultaneous Jones Act claim any further. As of now, no court has approached whether the preclusive nature many circuits find inherent in a formal award remains after they are found to be insufficiently final and therefore unenforceable in the district courts. The Ninth Circuit's decision in this case will most likely bring Grimm's dispute with Vortex into a new decade, since his initial claim was filed as early as 2010. With circuits continuing a trend of narrowly defining final LHWCA compensation awards, the Supreme Court may, in the tradition of Justice Story and his wards of the court, consider addressing this issue to ensure longshoremen receive expeditious workers' compensation under the LHWCA. Alternatively, Congress should further define the parameters of a final ALJ compensation order, lest longshoremen find themselves lost in a sea of judicial inconsistency. Thank you very much.